Chair Deputy Chief Justice Raymond Zondo has been criticized for allowing former SAA Board Chair Dudu Myeni not to answer questions on the grounds that she fears incriminating herself. So according to legal and constitutional experts, witnesses at a non-criminal tribunal do not enjoy the same right to remain silent. Just yesterday, Business Day was reporting that the State Capture Commission might in fact approach the Constitutional Court to force former President Jacob Zuma to honor its subpoena, compelling him to appear before the inquiry. Let's get analysis on both these matters from our guest, Cathleen Powell. She's an associate professor at UCT's Department of Public Law. Kathleen, thanks for your time. Welcome to the AM Report. Always great getting your insights on these matters. So let's begin with the Dudu Myeni saga, for lack of a better term. Do you think the Deputy Chief Justice was a bit too soft, too lenient by allowing her essentially not to give any answers, despite how pressing her take on what's happened is?
I think saga is the right word to start off. And yes, so far the handling of Dudu Myeni has been too soft, but we haven't seen the end of it. I'm wondering whether there may be a take two where they say, right now we are subpoenaing you to give this evidence. I agree that she cannot refuse to answer any questions. The only protection she has under the Commissions Act and under the regulations is that anything she says in the Commission inquiry, which does in fact incriminate herself, cannot be used in an actual criminal trial. So if she says in a criminal trial, yes, I shot him, that cannot be used against the, sorry, if she says to the State Commission, I shot him, that cannot be used in a criminal trial. The state can't say to her, hey, but you've already confessed. The state would have to prove separately that she shot him. Of course, they might be able to glean ideas of where to look for evidence from her from her evidence, but that's a different matter from whether she's actually incriminating herself.
Right, and it's a lot easier to make those points with the extremes. I mean, the example you make is a clear one. I think you don't even have to be an expert to follow, but there are significant grey areas, and perhaps that's what she's alluding to, right? Ways through which she might concede being at certain places, roles she might have played in certain times as a chair of SAA. Is that a sound reasoning to protect yourself from yourself, to use that controversial term, by not appearing before the State Capture Commission of Inquiry? I mean, is that not more of a sound reason why she'd want to be more cautious than anything else?
My understanding of the rule against how self-incriminating evidence can be used is that any statement she makes that has the effect of incriminating her cannot be used in that form in a criminal trial. So the state, if it's building on a statement she makes, like, I guess I was there, or this is how I understood a particular concept, it's got to show independently that all the elements of the crime have been met. It cannot say to her, you said at the State Capture Commission that you were there, therefore you're guilty of X, Y, and Z. So her statements can't be used. What can be used is what we call indirect evidence, and I'm using James Grant's example here. So this I shot him example could consist of two statements. I shot him and I threw the gun in the river. Now, the I shot him part would not be usable against Dudu Myeni, but the police could go to the river that she's named and try to find the gun. Now, if they then present that gun as evidence, that's permissible. It's indirectly obtained from what she said, but it's not her own statement against her. To see her in that commission refuse even to define reckless expenditure on the basis that it would incriminate her is risible.
The obvious question then becomes, what options are available then to the State Capture Commission of Inquiry if the Deputy Chief Justice agrees with you and many other experts who really have been unanimous in the fact that this is not really a path Dudu Myeni can go down? Are we seeing the possibility of yet another subpoena being issued out and the back and forth of a protracted delay possibly unfolding?
Yes, look, that's the next step. If she won't answer the questions willingly, then she has to be forced to. And the Commission needs to show that it's prepared to use its subpoena powers, which are powers to fine or imprison. Now, she might go the same route of Jacob Zuma and try to suddenly find some bias in Zondo, but I'm afraid if they play those kinds of lawfare games, the Zondo Commission nonetheless has to continue. It cannot simply sit there and say, oh, well, okay, you don't want to talk to us, that's fine. Dudu Myeni seems to be a very important witness, second only perhaps to Jacob Zuma. So yes, they have to get some answers out of her, spot the contradictions, make sure she establishes her version of events.
And at the same time, of course, the clock is ticking for the Deputy Chief Justice to have a final report with recommendations taking stock over the past few months. It should come perhaps then as no surprise that we're now seeing reports that the Commission might be resorting to the Constitutional Court in order to compel the former president to actually adhere to the subpoena they sent. Part of the reason they're giving is that this is because Zuma is an incredibly important witness and his evidence is crucial. I wonder whether that's enough reason for the Constitutional Court to essentially accede to their application.
This threat by the Zondo Commission confuses me, to be honest, because they don't need the Constitutional Court's help at all. They have the same powers of subpoena over former President Zuma that they have over Dudu Myeni. They don't need the Constitutional Court to help. So if President Zuma just doesn't pitch on the 16th and he doesn't bother to establish that he has a good reason not to pitch, then they can issue a warrant of arrest. They being the Zondo Commission, they can fine him or they can sentence him to 6 months imprisonment. I can't understand why they claim they need the Constitutional Court to help them with all of that. Quite apart from the fact the Constitutional Court has never in its life issued a warrant of arrest, it doesn't really have a role to play. The Zondo Commission has all the powers it needs under the Act and the regulations.
Yeah. I mean, would there be, call it, a channel for the the former president, I beg your pardon, to challenge this litigation all the way up to the Constitutional Court? And so could we perhaps read this from the Zondo Commission as an attempt to be ahead of those steps by getting the final arbiter, typically, which is the apex court, to make some form of ruling on this application? I mean, you rightly mentioned it is the first time that the Constitutional Court would have to weigh in this matter. I wonder whether there's any other significance outside of those two things.
I think that's a very good point. We've already seen Judge Zondo do something unusual, which is to put out into the open in advance of any recusal application what it might be that Jacob Zuma is going to claim is the bias. And he was doing that to shorten the process, in effect, to make things keep moving, because it looks as though the Zuma's legal team have said they're going to lodge an application for recusal, but they haven't done it. And if the Stalingrad tactics are continuing, which it looks like they are, then they will only lodge that application on the 16th, the day that Zuma is meant to actually appear before the Commission. So you're right that Zondo is saying, look, we're going to get the Constitutional Court involved now already, could be an attempt to forestall that whole process. But if so, I can't see it working, because to prove that you are treating everybody fairly and to comply with the rule of law, you would have to follow the normal steps for a recusal application, which would have to be that Zuma asked Zondo to recuse himself. Zondo would in this case say no. The evidence that he's put in the public domain is not enough at all for him to have to recuse himself, and then Zuma tries various appeals. It is possible for the court system to handle those appeals fairly quickly, and they can do so on the basis that this is an important matter. But I can't see the Constitutional Court risking tarnishing its own reputation for neutrality and impartiality by weighing in on the issue already now.
Your weighing in on this issue is interesting enough, so I guess we're going to have to wait and see how that all pans out. Appreciate your insight once again here on the AM Report. Cathleen Powell is a professor at UCT School of Public Law. Appreciate your time.